SJC-11894, Commonwealth v. Linda Mayotte.
Good morning, Mr. Brandt. Just give us a moment, and we'll get you started, all right? Okay.
Good morning, Your Honors. May it please the Court, Eric Brandt for the defendant, Linda Mayotte. Your Honors, this is an appeal from a number of, from convictions of a number of offenses allegedly committed by the defendant against her adopted son, whom we're calling DM. At trial in this case, DM testified that the defendant was having sex with her, raping her, that the defendant was having sex with him, raping him, for a period of several years, but the defendant took the stand and testified that wasn't true. In fact, she testified, I wasn't raping him, he was raping me. That was the entire basis for the defense in this case. Now, there was no independent evidence on that issue, no medical, physical, scientific evidence, so the case was presented to the jury as a pure question of credibility. Now, the principal issue in this appeal also goes directly to the issue of credibility. That's the first issue in our brief, which deals with the judge's exclusion of evidence of the defendant's first complaint. That's the issue that this court granted direct appellate review to consider. I'd point out at the outset that it's fully preserved for review. Excuse me. So in the time available this morning, I'd like to address 2 points. First, we say that the evidence was admissible, was properly admissible under the doctrine of first complaint. And secondly, even if it wasn't, it became admissible independently once the prosecutor opened the door to the evidence, which he did by repeatedly eliciting testimony showing the absence of a complaint by the defendant. That created a misleading impression that the defendant never made a complaint, and that rendered the defendant's complaint admissible to correct that misimpression.
On the first point, though, first, do you think, let's assume that your idea that since this is really to, it's not hearsay because it's not admissible for the truth, but it's only, for the same reason that first complaint evidence comes in for a complainant, it comes in for a defendant whose defense is that. Does the judge, what, if any, discretion does the judge have to consider the circumstances of the alleged first complaint? And can, because under Aviles, we would review that for an abuse of discretion, right?
Yes, Your Honor. I'd say that if a defendant's complaint meets the circumstances, that meets the parameters of the first complaint doctrine, that it would be admissible just as would a complaint by an alleged victim named by the Commonwealth. And that I suppose the same range of discretion would apply in both circumstances.
So in this case, as I understand it, the evidence that was sought to be introduced was a statement made by your client to Ed Gasser,
yes.
after the children had been taken from the house because of this, right?
Yes. Yes.
So would that, is that something that the judge could weigh in terms of whether it would be admissible or not as a first complaint?
I don't think so, Your Honor. In the King decision, the court eliminated the requirement of freshness so that
Well, it's not a freshness question. It's just sort of a circumstance that certainly weighs on the prior inconsistent statement argument, but I'm wondering whether it also weighs on the on this one.
Doesn't the existence of a possible motive to fabricate go directly to the question of credibility, which is not something that excuse me, that the judge can consider?
You need some water.
I'm sorry?
Would you like some water?
No, I just have had a head cold for about the last 3
But
weeks.
it's coming anyway. All right.
But I mean, if you're right, I mean, one thing which distinguishes the typical first complaint is that the victim generally has not been accused of rape.
Yes,
and,
that's true.
And your victim, your alleged victim, was, and the first complaint which you're seeking was not spoken until after that allegation was sufficiently ripe that her children had been removed from
that-
her.
Yes.
If you're right, does that mean that if somebody is accused of rape and has this as a defense, they could simply arrange to sit down and talk to somebody and give a complete description of what occurred, and knowing that that evidence would come in without the need for them to be cross-examined? I mean, it puts them in a position where if they're entitled to offer a first complaint after they've been accused of a crime, it puts them in a rather singular position to put forth their best argument without the risk of cross-examination.
I suppose that's true, but that could be true of in any situation. And for example, I'd point out that the Commonwealth's alleged victim, DM, his first complaint was made after he had been accused of a crime, the crime of stealing the defendant's jewelry.
Yeah, but it's not this
Nonetheless,
crime. I mean, this crime is the one that matters. Isn't it? Doesn't it?
I think the existence of a possible motive to lie is something the jury could consider, but I know it goes to weight and not admissibility.
Was there first complaint testimony by the, on behalf of the alleged victim in this case?
Yes, there was. And his first complaint was not made until the moment after he was accused of stealing the defendant's jewelry. So he, just as the court is suggesting that my client had a motive to lie, he would equally have had a motive to lie. He said that that he admitted that he did steal the jewelry, but said he was only doing it because the defendant was committing these sexual acts upon him. So he can, his complaint was admissible, and he could he could explain the circumstances. But I'd say all of these matters go to weight, to credibility, and not the admissibility of the complaint.
Now, what consequence, I gather there was prior statements that came in made to Joseph, that she had told Joseph about this allegation, and that came into evidence. So if you're right, how do we evaluate its consequence when the jury did hear that she had previously told her husband that this is what happened?
Well, first of all, it wasn't shown that she previously told her husband. Secondly, and the defendant's proffer was that the defendant made her first complaint immediately after the children were removed from the home. So on the defendant's proffer, at the hearing on the motion below, the complaint made to Mr. Kasser was on its face the first complaint.
Okay, but let's assume that's true. But let's assume there was a second complaint shortly thereafter to Joseph, which came in.
Well, it came into evidence, but there was a limiting instruction barring its use against the defendant and permitting its use only against the husband, and indeed as to one charge against the husband. So I think that's the answer to that, Your Honor.
Just purely as to the endangerment charge?
I'm sorry?
Purely as to the reckless endangerment charge against the
Yes,
husband?
Your Honor. And the instruction was in effect repeated in the judge's final charge, where he reminded the jury that certain evidence had come in for only limited to its application against one party, and emphasized that it could only be used against that one party. In this case, if the instruction was about the statement to Joseph, that emphasized that it could not be used against this defendant. As to the, let me start with the admissibility of this complaint under the doctrine of first complaint. I'm sure the court's first question here would be, isn't this doctrine limited to the first complaint made by the alleged victim named by the Commonwealth? And the answer is, well, no, actually it's not. Sure, we've all been accustomed to thinking about the doctrine that way over the years, but this court has never ruled that the doctrine is limited that way, and in fact, the court has never considered the question before said today.
What about other states? What about other states who have fresh complaint or first complaint kinds of?
What about, I'm sorry, I didn't hear
Because
you.
common law,
Yes.
and many states presumably have this or no longer have this.
They don't. Most states don't.
Most states don't have this any longer. When they did anyone recognize what you're suggesting?
I haven't found a case that deals with our situation.
If the judge, I'm sorry, go finish.
So, yes, typically we're accustomed to thinking about the first complaint is coming in from the victim designated by the Commonwealth. The first complaint rule deals generally with alleged victims, so there's nothing to exclude the use of first complaint by a defendant in prosecution for a sex crime.
If the judge in this case had not admitted the proffered first complaint testimony on behalf of the alleged victim in this case, would you be on less sure footing, as it were?
I don't think we'd be on less sure footing, but I think it would become much less important that the defendant's complaint was excluded. Because, and let me now skip to the second argument about the prosecutor opening the door, because that's, I believe, what's raised by your question. Regardless of whether the complaint was admissible under the doctrine of first complaint, it became admissible on an independent ground that the prosecutor opened the door to the evidence, and that she did by repeatedly stressing the absence of a complaint by
But
this
on
defendant.
that one, so it's a prior consistent statement, right? Or is that not what you're
Not a
after?
prior consistent statement. We don't argue that. The Commonwealth seems to have thought that we did argue that. That's not our
That's
argument.
not your thrust?
No.
Okay.
Our argument is that, let me start here. By the time defense counsel renewed her objection to the exclusion of the complaint, which she did during the defendant's testimony, during her direct examination of the defendant, by that time the prosecutor had stressed the absence of a complaint from the defendant, first in her opening statement, then during the testimony of 6 out of 7 consecutive witnesses, and what she stressed was that the defendant never made a complaint to them. I'd add parenthetically that after that, the prosecutor went on to stress the absence of a complaint more than a dozen times in her cross-examination of the defendant, and then again in closing argument. But right now, let me stick to the time when defense counsel renewed her objection. By that time, the effect of all the prosecutor's emphasis on the absence of a complaint had become very misleading.
But how did that play out? If there was in fact fresh complaint and the prosecutor was saying, and you never made a fresh complaint, what was the answer? Why wasn't the answer, yes, I did?
Well, because the prosecutor never framed it in terms of, she didn't actually say you never made a complaint. She said, well, you never made a complaint to this person or that person, this social
To
worker,
the DCF
that adoption
person,
aid,
to all these agency
all the
people.
DCF social workers, and the defendant acknowledged that she had not.
And on a redirect examination of the defendant, did counsel have the opportunity to say, well, if you didn't make a complaint to them, did you make it to anybody?
Well, no, because the judge had already excluded the complaint as a matter of law, and that was the proposition that they were operating under. Defense counsel did renew her objection to the exclusion. During the defendant's testimony, she said she wanted to call this witness that she wanted to call in the first place, Ed Kasser. And by that time, the complaint, we say, would, if it wasn't admissible under the doctrine of first complaint, it was admissible because the prosecutor had opened the door to it.
But the question was that argument pressed? In other words, did defense counsel get up on redirect examination and say, okay, you didn't complain to DCF, but isn't it true that you complained to so-and-so? I mean, was that effort made? Was the issue sort of squarely put before the judge?
She did not, but she did renew her objection to the exclusion of the complaint during her direct examination of the defendant. It's true, as we say, that it was not renewed on the basis that we're arguing here, that the prosecutor had opened the door by creating a mistaken impression about the evidence. The complaint was now admissible to rehabilitate the defendant's credibility. That's true, but we say that at that point, it should be viewed as preserved on this basis, the basis we're arguing here. Why? Because it was obvious that it should have been admissible at that time. And we have a case that says that that an objection should be, that a particular theory should be viewed as preserved on general objection, where its admissibility on that basis would have been obvious. This is the cancel case. It's cited in our brief. That's exactly what the case says. I know that this court doesn't wish to be in the habit of holding points preserved on the basis that they should have been obvious, but we say that this is one situation where we ask the court to look at the record, and I think the court will
Let me
conclude
just
that-
ask you, though, when she renewed her objection, was it in the framework of, still under first complaint framework?
The judge asked her, do you have any more witnesses? And she said, well, I would have had another witness, but my first complaint witness, but you excluded that. So unless that changes, we won't have another witness. So she is objecting again to the exclusion of the
Right, but
of the
it's in
evidence.
that context. It's in the, and
was
I
not
only raise it
stated in
because
new
because I think it goes to the obviousness of the other argument, or lack of. That's maybe.
Okay.
Well, just to be clear, I gather nowhere in the record are we going to find defense lawyers saying, Your Honor, the ADA just opened the door to this, it's unfair. Okay, so that's just not there.
We say that we acknowledge that in our brief.
Okay, thank
I
you.
see my time is up.
Thank you.
Thank you, Your Honor.
Good morning, Ms. Lazar-Moore.
Good morning, Ellen Lazar-Moore for the Commonwealth. This court should decline the defendant's request to extend the first complaint rule to criminal defendants and should affirm the defendant's convictions. At its heart, what the defendant really seeks to introduce here is self-serving hearsay.
Why do you
which-
call it hearsay, Ms. Lazar-Moore? I just don't understand why you say that. It's not admissible for the truth of what's stated.
Well, if this court were to extend the first complaint rule and to say that this evidence could be admitted in a defendant's favor and limited to corroboration, then no, it would not technically
Well,
be
isn't that the
hearsay.
argument that Mr. Brandt is making? He doesn't say it's admissible for the truth.
No, but that is essentially what the defendant is looking to do.
But that's what the
This is
Commonwealth wants to
evidence-
do also.
Yeah.
Excuse me?
It's the same thing the Commonwealth seeks to do. It's the same type of evidence.
Even if the evidence is limited to its effect only for corroboration, this is evidence that is inherently unreliable. The reason why self-serving hearsay by defendants to bolster their cases is generally inadmissible is because it is inherently unreliable. A
But
defendant,
isn't this a result of an accident of circumstances? I mean, if you had believed that the defendant in this case had in fact been the person who was raped, she would have been the named victim in the case, and the child would have been the defendant. And the first complaint evidence would have come in those circumstances.
and then the defendant would have been the complainant. But the fact is, she was not. The defendant was the defendant, and a defendant in a criminal case has an inherent motive to lie.
Oh, Ms. Lazar-Moore, we don't do rules of evidence on the basis of somebody has an inherent motive to lie, do we? I mean, isn't this a
Well, we
neutral rule
do.
of evidence?
When a party is seeking to admit out-of-court statements, then there is an examination of the reliability of the evidence.
As a
That is
matter
the
of law?
basis- Yeah, that is the basis of most hearsay exceptions, is that the evidence is considered to be reliable for one reason or another.
Right, but this isn't hearsay.
The purpose for which the defendant sought to have it admitted, yes, it would have been limited to corroboration, but as several questions noted here, this complaint was not made until the defendant had been accused of raping her children and her children had been taken from her. That is a circumstance in which the evidence is inherently unreliable, whether it's admitted for corroboration or for its
But is
substance.
that really different than when the Commonwealth puts on first complaint testimony in connection with the person whom they believe has been victimized?
I don't believe it is, although there are particular cases where a
Because
defendant
sometimes
may...
that is made belatedly.
Yes, and in particular cases, a particular defendant may elicit evidence that this complainant's complaint, for some reason, is unreliable. But it cannot be said that across the board, every complainant has a motive to falsely accuse someone. But it can be said in this circumstance that there is a built-in bias and a built-in motive to lie.
So could a prosecutor get up in closing argument and argue to the jury that a defendant has an inherent incentive to lie in a criminal case, and you can't believe anything that he said from the witness stand. Is that a legitimate argument?
I think that, in essence,
Have a
it would
case
be.
last
I mean,
term that
perhaps-
said you can't do that?
Perhaps not to say to a jury, every defendant, this defendant automatically has a motive to lie. That the prosecutor would have to point to particular aspects of the testimony, but that's not what we're talking about. We're not talking about an argument that a prosecutor's making to a jury. We're talking about an exception to the general rules of evidence, and those do consider the reliability of the evidence.
Well, let me
Keeping-
give you a slightly different set of facts, okay? Let's imagine in this particular case that the first complaint was not done after the children had been removed, but before, in which she was speaking to a therapist, telling them about this particular circumstance. Inherent motive to lie?
I think there may be other evidentiary circumstances where a statement like this could be admissible, like prior consistent statement, which is a basis that the defendant now argues should have allowed the admission of the statement. It didn't apply here because the statements were made after there was a clear motive to lie. But it could be admissible as a spontaneous utterance. It could be admissible as a prior consistent statement if it fit other evidentiary considerations. But what the defendant is asking for here is to extend a very limited rule. And if you look at the history of the first complaint rule, it's clear that it's derived from the prosecution's inability to make its case without corroboration of a sexual assault victim. And as the trial judge noted at trial, there's no equivalent burden of proof upon a defendant. In fact, the jury are repeatedly and explicitly told that they may not consider a defendant's failure to bring forth evidence, that they may not hold that against a defendant.
The same token, you cannot deprive a defendant of making a defense.
And the defendant was not deprived of making that defense. This defendant took the stand and repeatedly testified that the victim was the aggressor in the sexual contact between the defendant and the victim.
In that
The only-
context, but in that context, it's the same situation of not being believed because you haven't said anything to anyone. It's the same phenomenon of not having raised the hue and cry, but whether or not it's still a valid point or not is debatable. But it's as valid on the part of anyone who claims to have been victimized.
If the defendant were the complainant in the case, that would be true. And if the defendant sought to bring charges against the victim, then in that case where the defendant was the complainant, then that would be true. The defendant was not prevented from raising this defense. The only thing she was prevented from doing was bringing in an out-of-court statement that was inherently unreliable, as every other criminal defendant in every other context is prevented from doing. There's no reason to make an exception to that general rule in a sexual assault case to allow inherently unreliable evidence to be placed before the jury.
Well, what was the basis for the prosecutors asking the defendant on cross-examination whether or not she had told the DCF workers and certain other people that she had made a complaint?
And and she did ask those questions, but
Well,
she
what's the
never...
basis for it if it's unreliable?
The basis for it was the fact that the defendant's claim that she was not the aggressor was a fabrication. And
So
the-
if on redirect examination, trial counsel had asked, well, did you tell so-and-so that this had happened? Would that have been a permissible question?
I don't believe so, because I think it would have been trying to introduce a prior consistent statement made after the motive to lie had arisen. And what the prosecutor did here was not, she did not say to the defendant, you never told anybody about this. She specifically said, before the disclosures of the sexual assaults happened, you were meeting with GCF workers. Did you tell any of them? No. You were meeting with a therapist treating one of your adopted children, one of the victims. Did you tell her? No. The defendant did the exact same thing to the victims. Up until the final disclosures, the male victim did not tell anyone, and he was heavily cross-examined about the fact that he denied abuse to DCF, he denied abuse to the police, he denied abuse to a therapist. The female victim was similarly cross-examined about the fact that at first she made an allegation and then she withdrew it. The cross-examinations were very, very similar in that regard. Neither in her questioning nor in her opening or her closing did the prosecutor ever say, this defendant never told anyone. She specifically said, prior to the disclosures by the victim, she met with police, she met with DCF, she met with adoption workers, and she did not tell any of those people that this victim had assaulted her.
You don't see the problem of having kept it out and then making that argument? You don't think that's a problem?
No, I don't, because the defendant did not have a right to corroborate her own testimony with her own out-of-court, unreliable statement. And the argument that this was a prior consistent statement that should have been admitted to rehabilitate her, A, was not made at trial. I disagree that the defendant renewed an objection or that it should have been obvious to the judge that the defendant wanted to do this. All she said was, well, I would have called that first complaint witness, but you already told me that I can't. So in no way would that have alerted the judge to an argument that, hey, the prosecutor opened the door, I should be able to put this in, I should be able to rehabilitate my witness.
Well, the judge is sitting there listening to the evidence, right?
Yes.
So the judge would understand what that means, he or she.
I don't think the judge would have understood that when the defendant said, I would have called a first complaint witness, but you won't let me, that meant because the prosecutor has now questioned a bunch of people about my failure to make a complaint, I should now be able to rehabilitate my witness. There was no suggestion in any argument, in any statement by defense counsel, that that was a new alternative reason for putting in that evidence.
So on Chief Justice Gantz's example, if the disclosure had been made to a therapist before the arrests, before that
For the
makes no
allegations.
difference? Before the allegations, that makes no difference?
I
Yes.
think it potentially could have then been admissible as a prior
Not as
consistent
first complaint.
statement, but not as first complaint. And again, the defendant didn't seek to admit it on that basis.
As first
and
complaint, they did.
As first complaint, they did. But again,
You're saying under no circumstances is this applicable to a defendant?
not the first complaint rule. If you look at the practical effect of what the defendant is trying to do here, it would threaten to derail an entire trial, to divert the jury's attention away from the crime on trial, away from the defendant, onto allegations that a defendant is now making against the victim. If you look just particularly at the first...
But that was his defense. I mean, that was her defense. So how can you say it's a diversion? That was her defense.
Because of the sort of breadth of what the first complaint rule would allow. It would allow not only the defendant to testify to what she told the complaint witness, where, when, how, why I decided to tell now, and then the complaint witness to testify to all of the circumstances surrounding it. And then if you look at the potential jury confusion caused by the first complaint instruction, which repeatedly refers to the complainant saying this or that. Does it support the complainant? Does it corroborate the defendant, the complainant?
The judge can
It talks
fix
about
that. I mean, the judge is not required to give it as it is in the model instruction. The judges modify instructions all the time to fit the circumstances, so that's not a reason.
But if you look in particular at this instruction and the multiple references to the complainant and the crime, it's really ill-suited to a modification where now the defendant is actually the complainant and the crime is not the crime that's on trial before the jury. It's some other crimes that the defendant is accusing the victim of.
So in this case, I just want to make sure I understand what the facts are. Was the defendant's proffered first complaint testimony a statement that was made after she had been accused of rape?
Yes. She was accused of rape. The victims disclosed. They were taken from the home. And this is to the extent we even know what the first complaint testimony would have been, because it was very, very limited. But all she said was that within days of the children having been taken away, after the disclosures, she told her friend Ed. Now,
If I could turn you to the issue of sentencing.
yes.
Is it appropriate for a prosecutor to argue for a sentence saying that the defendant lied on the stand?
Not to ask the judge to punish a defendant for lying on the stand, but I don't believe that that's what the prosecutor did here. I think that if you look at what she said in context, she's in the middle of listing reasons why there was no mitigation, why the judge should not grant any leniency to the defendants. And one of the things, or several of the things she lists, are that the defendants showed no remorse and they lied and they accused the victims. And I think that
But how is a defendant who goes to trial supposed to show remorse when they testify at trial?
I think if you look at it in context, she's referring more, not so much to their testimony at trial as to their behavior sort of outside of the trial itself. But
Because they
even-
didn't plead guilty?
No, and I mean, the cases recognize that there's a difference between punishing a defendant more harshly for going to trial and not granting leniency to a defendant who goes to trial, like in the plea context. And I think that if you read the argument in context, that it's more that. When the prosecutor's saying there's no reason for mitigation here, she's more saying there's no reason to give them leniency because they have not done these things. But I would also say, both as to this and the other comment about sending a message, which I acknowledge should not have been said, that there's no indication whatsoever that the judge acted upon those comments.
Wait, see, how are we supposed to know that? I gather the judge simply said sentence and gave no explanation.
He gave no explanation. He did talk to the prosecutor and say, I see that you're saying no probation. Why do you say that? There was a little discussion about that, just having to do with the ages of the defendants. He departed significantly from the request that the prosecutor was making, which was 30-year minimum, and he gave an 18-year minimum. And I think the court presumes that judges are aware of the law, aware of the factors that they may consider at sentencing. And when there's no indication whatsoever that the judge departed from that, there's no reason to speculate that he did. I cite one particular case, D'Amour, where the court says the court won't presume that a judge considered a factor just because the judge didn't say that he did not consider that factor, that we presume that judges act appropriately in the absence of evidence that they didn't.
Thank you.
Thank you.